Welcome to our last pop-up before the spring break. Congratulations through making it halfway through the semester. I'm sure you all are excited to go off and do whatever it is that you're going to do. But I will tell you, don't forget completely about EagleWorks when you're down in PCB having fun or whatever it is that you're going to be doing. So we will be in this competition very, very soon. I've been saying since October, what? It's going to be here before we know it. Guess what? We're a month out. That's kind of crazy, but it's also really great, and we're excited to see you all here. And thank you all so much for continuing to come to these pop-ups. Hopefully they are providing you with the necessary skills and abilities that you're seeking through EagleWorks. Now, we do have a shirt giveaway tonight, so at the end of how do you want me to address you? Dr. Moore, Kent Moore?
No, Kent
Attorney Moore?
Yeah.
All right, so
Kent
we have Attorney Kent Moore with us tonight, and he's going to talk to us about intellectual property and some considerations. So without further ado, I think what we'll do is we'll let Mr. Moore come in and do his thing, and at the very end we will do the shirt giveaway. Do you have any opening statements or announcements or anything that we need to get out of the way before?
No, but just I'm sure Jeff will let me know, Andrea will, when you get farther on along in your program, get your ideas, your concepts developed, or if I can't make any of that, I certainly want to be at the final selection or whatever y'all call it to see who wins.
Yep, main competition.
In this sort of thing, though, everybody who has committed time to this wins, because you learn about the grind, you learn about the commitment, you learn about the time it takes, and those are invaluable skills and things to have in your toolbox for later, regardless of who takes home the grand prize. So hats off to all of you for committing to this. That's huge.
So
Very
Kent's
well
on
said.
our board, so he's heavily involved
Let's
in the
take a
Biz
look.
Foundry, and so knows 90% of the startups we're working with, and then winds up doing all our legal work for, I know sometimes he doesn't want to answer my phone when he sees my number pop up. But and one of the things he's also going to mention is entities, because everybody tells you ought to do this and you ought to do that. So he's going to address some of those kind of things. And then his main business practice is partner divorces, right? So he's also going to talk for a minute about, even at this level, if there's a chance this thing could become real, take a page off that and write up some kind of agreement of who all's the original founders, and just a little bit of stuff that he'll touch on that we see every week. I mean,
I see things, just to give you a little history about myself, I've been practicing law for 23 years now. Most of what I do is special projects, I call them. I help people separate. It's business divorce, whether it's a partnership, a corporation, an LLC, things have gone wrong. 99.5% of the time, things rock along just fine. I get the 0.5% of things that have gone, taken a turn off the side of the road in the ditch. And so people have to split up. Trust is gone. Somebody's stolen something. Somebody's done something they don't like. The relationship is irretrievable. And so I get a really close-up view of what went wrong in the beginning, and the problems and difficulties people have in separating things when it's become too late is document-driven. They did not prepare the documents and do the things they needed to on the front end, and it just complicates things, because then we're relying on, well, he promised me this, and she was supposed to do that, and I had shares, and all of the things you can come up with, but we don't have a document to support any of those claims. So I see what goes wrong at the end, and so it helps me in my advice on the very beginning, the very outset of businesses. Now, I'm going to talk mainly tonight about intellectual property. I'm going to touch briefly on Tech's policy of intellectual property, maybe do a little bit on entities. I've got a few slides, but I decided just to do heavy on intellectual property at this stage. I will get through enough of entities to kind of give you some rules of the road of where to go for your group collaboration, because that could be important. I wanted to start off, though, with a different approach than what I normally do, a philosophical question. What's the point of intellectual property? And if you've never, I don't recognize anybody except this group over here. But if you've been to one of my talks before, I like to be very interactive. I like you to ask questions. So that's, these aren't rhetorical questions for me to answer. These are for you to think about and give answers to me right now if you want to. If you don't want to speak up, that's fine, but yes, sir. What's the point?
Temporary monopoly.
Okay, that's a good one. That's not one I had up there. That's a great one, though.
You may steal it.
What else? I'll just start putting them up there. Well, they're all going up there. For individuals or businesses, we're going to protect our assets, right? Intellectual property is an asset. We're going to protect it. Value. We bring value to the business by having some sort of intellectual property protection. Intellectual property, and particularly trademarks, that's our branding. That's our Nike, Apple, Disney, Kodak, you name it. Branding is important. Anybody have kids? Do they recognize the golden arches at McDonald's at a very young age? Yeah, branding is valuable, absolutely. Kind of go along with that, you establish your identity. All of those things are important. I'm adding that to the list, though. You get a temporary monopoly. You get it's a quasi-monopoly. You get an exclusive right in whatever your intellectual property is. It's not a classic like a towering monopoly like Microsoft would be in the classic sense of a monopoly. You've got a huge market share, that sort of thing, but you do have some exclusive rights. And for society, now I was just talking about oh, that's right, these pointers don't work they disappear on the screen. For society, though, we foster innovation. We foster innovation. Imagine, if you will, you've invented something. You're getting ready to spend months of your life that you didn't have to spend with a bunch of people that you didn't have to spend it with, working on something that you think is going to contribute to society, turn a profit for you later on, make a good living for you. And then you get to the end, you've sacrificed, you've put off family, you've put off vacations, you've come out of pocket all you can. And then somebody can just come in and say, hey, I like that, I think I'm going to take that. And there's nothing you can do about it. Would you ever engage in that exercise again? No, of course not. It's futile. You're going to work so somebody else can just hijack your work product and they'll go make money off of it? No. Even the framers knew the innovative component of intellectual property. They ingrained it in the Writings and Discoveries Clause. It's Article 1, Section 8, Clause 8 of the United States Constitution. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, innovation is not something that is just, oh, we just thought about that in the 21st century. We go back in time several hundred years to the geniuses that wrote our founding documents to find that. There's 4 main intellectual property protection components. There's patents, trademarks, copyrights, and trade secrets. Patents, trademarks, copyrights, and trade secrets. Basically, on really 3 of the 4, I broke it down into a little bit more. One of the 4 patents involves 2 basic steps. You create something, and you file something. You've got to do that for a patent. You have to file something. For trademarks and copyrights, you create something, You might want to file something, but you don't have to. Lump those all in to create something and then file something. Trade secrets, you create something and you don't file it, because when you file something, you're filing it publicly. It's a public record. With trade secrets, you create something and you keep it secret, you guard it. You do not file it, record it, disclose it, let it out into the public domain. I'm going to start with trademarks. Just to skip to the end, to kind of tie in with the interactive component of this, I open up for questions and answers. Feel free to ask me anything you want to about any of this, and I will gladly give it my best shot. We've got the Trademark Act of 1947. There's the statutory reference. That's the Federal Trademark Act. That's the big one. You get the most protection under that act. Most states have some form of trademark act, but all it is you send in your name. They do a general check on their existing database. It has to be distinguishable from all existing recorded names. Other than that, they just record it. They don't examine it, search it. They don't do anything to otherwise compare with any existing trademarks out there. They let the courts figure out in litigation your trademark rights. That's in the states. With the federal scheme, though, you get a little bit better protection. You file a registration application. They examine it. They publish it for opposition. It goes through some scrutiny. So it's a little bit more hefty when you're granted that registration on the federal level. What is a trademark? Well, there's some description up there. It's a logo, or a word, a design, a phrase, a slogan. It can be sounds. Harley has trademarked that real guttural sound from their motorcycle engine. NBC, bum, 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 that's a trademark sound. I think the MGM Lion Roar is a trademark sound. So it can even be sounds. It's any of those things actually applied to goods or services. Okay. Well, I said, there's the golden arches right there. I'm loving it on your laptop. But you'll see the ThinkPad right there. You see the windows. Those are examples of marks that are actually applied to the products. If it's impractical to apply a mark, you put it on the labeling, packaging, things like that. Your trademark, logo, mark, word, phrase, slogan, whatever it is, must be distinctive, fanciful, or arbitrary. We'll talk about that in just a little bit. If you fall into those three categories for your mark, you skate through registration process on the federal level. Don't use, if you can avoid it, descriptive or generic terms for your brand. Right? Generic. Here's some examples of generic. An escalator. These are these were actually trademarked or registered names that have since become generic because of usage. It's a moving staircase. Aspirin used to be a registered trademark. Now it's just a generic name. Thermos, cellophane. Then you actually have your actual names. Light bulb, paperclip, pencil, pen.
Band-Aid.
What's that?
Band-Aid.
Maybe. I bet Band-Aid might be in jeopardy. I think Band-Aid's actually a registered mark, but people use it.
It's an
People use it
eponym.
interchangeably for a wound bandage.
Xerox.
Xerox
Kleenex.
went on a
Kleenex,
big
yeah.
campaign. People would use Xerox this for me?
Right.
Instead of copy. And Xerox went on a campaign of Do not say Xerox. It's not a verb. Copy is the term you're looking for. Xerox is our registered and protected trademark.
Band-Aid is a registered trademark.
Yeah.
Google.
But a great example though of how we think a particular word may be generic, when at one time it was probably, cutting edge. Just remove all prior knowledge of what Band-Aid means, okay? When you hear the word Band-Aid, what does that conjure up? I mean, not a whole lot.
Band
What
director.
what does Xerox conjure up? Or Apple? Apple conjures up a physical Apple, but that's not what we're talking about. We're talking about iPhones, Macintosh. And so that's the spectrum we're on now over here. These immediately protectable, Exxon, Apple, they're arbitrary and fanciful. I also said they're distinctive too. That can be another name. When you say the term, it conjures up absolutely nothing related to anything of the product. Okay. Yeah, Apple conjures up an apple, but when you say the term Apple, it conjures up nothing in your mind of what the actual product would be. It is so far removed from the product. It's distinctive. It's fanciful. It's arbitrary. What's a Kodak? If you didn't know Kodak was associated with film, like, well, is that a place in Alaska? You don't know. That's the end of the spectrum you want to be on. You never want to be over here, beer company, American Airlines. Now, interestingly enough, Burger King is middle ground, and I've got an example of that coming up that I use in a lot of my discussions. It's in the suggestive category, and the wording implies it's immediately protectable, but it's not. You've got some hoops to jump through if you're in sort of this descriptive middle end. You really want to avoid that if you can. So that's just kind of some rules of the road of, how to name your product. What sort of brand name you want to come up with. You want to be on the fanciful and arbitrary end of the spectrum. Now, this slide here, branding obviously is important. I gave you an example of a great brand and why branding is important, because branding can be identifiable by people who barely have learned the English language. And you'll pardon me, my collar stays are not in, so if my collar flips up. But consumers will eventually identify that mark with your products. And it's a little counterintuitive at first. You think, well, if I give my product a more descriptive name, if I describe what it is, then that'll be a little bit better. This whole notion of giving my product this weird brand name, how does that generate customer recognition? Well, Nike. I'll just toss that word out there. I imagine at some point in time, Nike, people are like, what's a Nike? Look at them now. The more disconnected the name is from the actual product, when customers actually make that connection, the stronger the brand will be. It will be impossible to disentangle the brand name from the products in the consumer's mind. That's important. That's branding. You also want to distinguish your goods and or services from goods and services of somebody else, right? We're not here to rip off other people's intellectual property. We don't want, we want our own strong brand. We want to build it ourselves. We don't want to take innocently or on purpose from somebody else. We want to distinguish our goods from other folks' goods in the, in our channel of commerce. Here's a bunch of just really strong brand names. All right, so you've got an idea for your mark. What next? One of our goals was what? Protection. We want to protect our brand. Well, don't think for a second other companies aren't doing exactly the same thing, all right? And if they got there first, in terms of brand name or logo or whatever it might be, you might have an infringement problem. All right, infringement problems. And you think about this: you're trying to come up with a whacked name. You'd be surprised how many people come up with something like that, and they go to searching. Son of a gun, somebody came up with that name already. So our concern is we don't want infringement. We don't want our name, brand logo to be confused with something else that's pre-existing out there, because they're going to jump on us if we come up with something that's the same. Just like if we go to all that trouble, we establish our brand, and there's some Johnny-come-lately who starts trying to play off our name, what are we going to do? We're going to send them a nasty letter that says, no, you can't do that. That's too much like ours. People are going to confuse you with us, and we don't want that. Infringement just is using a confusingly similar mark in a related channel of commerce. And I don't know, I put a question mark together. Using a confusingly similar mark in a related channel of commerce. Now, I said that term, channel of commerce. I don't know if, I need to probably back up a little bit and explain what that is. You know, if you're in beverages, all right, well, that's going to be different than backpacks. It's difficult to confuse a beverage with a backpack. So if I have cafe as my mark for a coffee beverage and cafe as my mark for a backpack or a satchel, well, we're in different channels of commerce. People aren't likely to confuse backpacks and coffee, right? So that's kind of, that's what a channel of commerce is. Beverages, sporting equipments, apparel, you name it, just different channels of commerce. And so then the question is, now knowing what the test for infringement is, Lexus, car brand, right? And Lexus, database for legal research, publications, that sort of thing. Does one mark infringe the other?
I'd say no,
You'd say no. Why?
because they're in the opposite markets.
Yeah, it's a different channel of commerce. Now, notice though, if I say Lexus and Lexus, phonetically, they're spot on. Can't really tell a difference. So at first blush, at first listen, you think, oh, that's exactly the same. Infringement. Well, no. They are even though they might be confusingly similar, they're in different channels of commerce. Now, let's go back to right here. There we go. Apple, Exxon, Nike. There is a trademark registration on steroids. It is called a famous mark. It is the root card of all trademarks. All right. If I made an Apple briefcase, all right, If you're in the famous trademark category, you don't have to concern yourself with channels of commerce. If you're famous, then if I put an Apple logo on a briefcase, if Apple's even said under oath, we don't like briefcases, we never will make a briefcase, we have no plans to expand into briefcases, even if I got that under oath, it would not matter. If you're a famous mark, you can stop infringing use of confusingly similar marks, no matter the channel of commerce. It takes a while to get. Yes, ma'am?
So was Lexus not large enough in order to have that route?
I don't think so. I don't think they fall into the famous category. There's actually a case. Now, you know, that's a good question. The case is probably 20 years old. So maybe things have changed a little bit since that case. I wouldn't think so, but yes, sir.
Is there like a limit to what makes a company famous, or is it just something that's kind of up in the air?
In court, you're going to have to put on proof that your mark is famous. That's not something that is a status granted by the Patent and Trademark Office. I've never tried one of those cases, so I don't know what the proof is to prove to the satisfaction of a federal court when you get that famous status. There's some that are just obvious. So just some practical points here. You know, when you're trying to think of a name, you're going through the iterations, conduct some searches, okay? Get on Google. They're pretty good. And just type in the actual name, phrase, whatever it might be, and phonetic sounding variants thereof. Because you want to make sure your mark that you're wanting to use and ultimately register is not similar or confusingly similar to other existing marks in your channel of commerce first, but remember you also want to search famous brands too. And you can also go here, uspto.gov. Is this touch screen?
No.
Okay. And you can search the database of registered trademarks that are live and that are what are called dead. They're no longer protected anymore as registered, but they're still on the database. Yeah, and then the other points. Watch for your optics on some of this stuff. Really poor choice of.
For the longest time, I thought Electronic Express was actually Electronics Express. How many of you all thought Electronics Express on Jefferson has an S on it? It actually doesn't, because if you put it together in their URL, I kept getting a wrong website. It's Electronic Express, not Electronics Express.
That's funny.
Oh, for fuck's sake.
Okay, so you got whatever it is that you're gonna put your mark on. You've put your mark on it, and you put the little TM by it, trademark and superscript, and you start selling it to the general public. Guess what? You have trademark rights right then. You don't have to register with a state. You don't have to register with the federal government. Your trademark rights begin with your first use, your first sale. A lot of people confuse what goes on at the Patent and Trademark Office with having a trademark. You are registering your pre-existing trademark when you go through the Patent and Trademark Office. You're registering it. You're not getting a trademark. There are some differences, though. So trademark rights begin once you use your mark in connection with goods and services. You register at the Patent and Trademark Office. We'll talk about those advantages here in a second. Use the TM as an indicator. Now, before you can register at the Patent and Trademark Office, assuming this is an imaginary state line right here, your goods or services have to cross state lines in interstate commerce. That's the jurisdictional hook that a lot of federal agencies have, is interstate commerce. Congress can regulate anything in interstate commerce. If it's intrastate, Congress has more limited options. But getting your mark used in interstate commerce is going to be one of the keys to registration. This is the advantage. This next couple of slides, I'm going to go through a famous case that illustrates the advantages of registration. Registration basically means that's your territory, that's your geography. And here's what I mean by that. There's a little city, probably 18,000 people by the 2010 census in Illinois called Mattoon. It's mostly on the west side of I-57. And in Mattoon, Illinois, there is that restaurant. And that's a fairly recent picture, I believe. Anybody notice anything missing? Odd?
They're not affiliated with the chain, are they?
That's right. There's no Whopper, whatever, BK, Burger King logo that they have. This is one of the first Burger Kings. This is not Big Burger King. This little burger joint started long, long ago. I think it may be in the 40s or 50s. And it had first use. Little Burger King, though, I mean, you can see the sign. I don't think that's changed in 50, 60 years. It doesn't have a little TM by it. Notwithstanding that, they used their name in connection with a good or service in this little geography named Mattoon, Illinois. They got some trademark rights, okay? Here comes Big Burger King. All right? They're somewhere else. They're not in Mattoon, but they actually come along later. They call themselves Burger King, and they register. So they have trademark rights, and they register at the Patent and Trademark Office. Then they send a nasty letter to Little Burger King in Mattoon, Illinois, and they say, we've got our registration, cease and desist, or we're coming after you. We're coming into your territory, and you're going to have to debrand. And Little Burger King went and found a lawyer, and they said, and they fought back. Anybody know who wins?
Little Burger King, if it's
Little
still there.
Burger King, if it's still in that modern picture, that's right. Why did they win? First, Big Burger King started in another part of the U.S. They started later. Little Burger King was using their trademark before Big Burger King in a little geography, okay? So they had pre-existing trademark rights. Those attach. Those are, if you're first, then, and they attach to that geography like they did here, there's no takebacks. You can't lose them. And then, of course, Burger King sued. Actually, they both won. the court said that, yeah, Mattoon, Burger King, since your rights attached first in that geography, you get that geography. Big Burger King, since you registered, your geography is everywhere else in the United States. Yeah, I see a couple of you go, wow, yeah, that's registration. Your registering gives you the entire geography of the United States, carving out little prior users here. Okay? Yes, sir.
What if the same sort of thing happened except both or one of the companies sold their products online?
Don't know.
Sounds like
Big court case, though.
Probably depends on who your customers are. Are they selling dollars in the US?
I can't imagine a court, if they sold them exclusively online,
Yeah.
it's whoever gets there first.
Because it'd probably fall back to the domain registration at that
I
point.
think
or
so.
something.
There are different rules for online only. If it's a combination, if you have, then you just kind of bolt it onto this analysis. They used in Burger King Mattoon first, and they can sell online. That doesn't matter. But their geography is going to be fixed there. It'll be the same analysis. If it's online only, I think we default to a different set of who gets the registration first, who gets the domain name first, who's.
But they could still sell online anywhere.
You know, online, if you know, you can get in trouble for cyber squatting or using somebody else's name in the online world. And I confess, I'm not too familiar with those rules. That's a different set of rules, though.
So, and is it the company name or a product name, right?
That's
'Cause
right.
That's two different things.
But in the end, though, the analysis is the same. Are they in similar channels of commerce? Do they have confusingly similar names? In this case, they've got identical names. And who has prior rights? Okay, that's kind of the big thing in cyber world. Who's got prior rights? Yes, sir.
I wanted to make a comment on the big Burger King versus the little. I know everybody was raising eyebrows and stuff like that, but that actually sounded like a really fair ruling to me when you think about it. Because, I mean, yeah, Little Burger King was there first, and nobody likes to hear about the little guy being capped off and being said, no, you can't. But at the same time, if they were to expand using that trademark, they would be profiting off of decades of incredible investment on the part of Big Burger King. So that just sounded like actually sounded like a really fair ruling to me. It's like, no, you leave the little guy alone, but don't think you're gonna profit off of everything they put in.
I think so too. I mean, I think the gasp you heard, I think, was from people learning that registration gives you that big of an advantage. I don't think it was that, Little Burger King couldn't operate anywhere outside of its territory. I don't think that's why the audible gasp. I think, it's kind of a similar reaction. Holy cow, that's what registration does for you. You got the entire United States. Like, if you're in New Jersey and you register and you're first, you win all the battles and everything, and you find somebody out in California who's using your brand, well, you can send them a letter even if you're not in California. And you can get them, if they're in same channel of commerce, confusingly similar, you can send them a cease and desist letter and attach your trademark registration to it. It's powerful. Territory is your registration gives you the entire U.S. as your territory.
A quick question regarding that.
Yes, sir.
How do you prove first use if you don't go interstate commerce?
How do you prove first use? Well, invoices, sales tickets, I mean, you're gonna have a record, unless you just, cash.
Well, I'm thinking like small thing, set the website, selling like t-shirts specifically.
Well, if,
Outside of like my little.
if you go it alone, and, oops, I'm sorry about that, those things got intertwined. If you go it alone, and you just have products that you sell, and they happen to go across state lines, and somebody says, hey, you might want to go see a lawyer. That's one sort of fact pattern that a lot of people fall in. But if you're putting TM, if you're making a conscious effort, I need to get this across state lines, you've probably sought counsel. And that lawyer's going to tell you to keep records. That is a big deal when you can prove your product crosses state lines. So it's not going to be without some advice and guidance. It's not, most of the time, if you're at that point, your lawyer's told you what you need to do. Otherwise, you just have to backfill. If you just kind of stumble into it, maybe you can't prove it. Maybe you gotta wait. There's, the fact patterns are endless. There's no guarantees that you'll be able to prove your earliest first use if you don't have adequate records. And you could lose a battle in court over it too. Somebody could actually be a later user, but they have the records. You're the first user, you have no proof, except your verbal testimony. And the jury can weigh credibility of the parties and the testimony and believe one over the other. You could lose. Yes, sir.
How significant of crossing state lines have to be? Like you mentioned, selling T-shirts. Let's say your stands in Tennessee, but you have family in Florida or something, and you sell them 5 T-shirts. You're crossing state lines, but it's such a small scale. Would that still qualify for federal trademark?
I would do something to generate an invoice. Prepare the paperwork. Don't rely on sort of the, well, yeah, they bought it here. They told me they were from Georgia, or my family bought a T-shirt. They're from Florida. Be purposeful about it. Don't rely on just happenstance and.
Yeah, but so let's say you have the invoice from the Florida family saying, hey, we sold from Tennessee to, whatever in Miami. If you have that invoice of just the 5 shirts, would that count? Would that qualify?
Yeah. What you're gonna do when you fill out the application, I think it's a check the box now. Is this used in interstate commerce? Provide some documentation. Toss it in there.
So you could really easily just go to a different state and sell a product or a service.
Sure.
They don't say it has to be $1 million. They just say
Yeah,
you have
they'll
to
say
have
across state lines,
conducted
yeah.
commerce across that state line. That's
Okay.
all they say.
Yeah.
There are, and I'm not an attorney, but sometimes where you're showing your advertising in an area, right? That can even be construed as you're conducting commerce there. Just because you hadn't made any sales yet, you're paying a billboard company in Florida to do billboards
Right.
using that mark that, you are promoting your company in that state, right?
Yep.
So can it be as easy as running a targeted Facebook ad
Yeah.
just the next day over?
Like a select mile sticker.
As long as it results in whatever you're trying to, all right, so on the trademark application, it's very specific. It's channel of commerce specific. What are you trying to trademark? Tennessee Tech. What are you going to apply it to? Well, clothing. Okay. So you check that box. Whatever you check, or if it's golf balls, sporting equipment, if it's, you name it, beverage containers, everything's got a channel of commerce, and you pay a filing fee depending on how many channels of commerce you're in. So, if you want to sell a whole wide range of, you're going to have a real expensive trademark filing fee. Let's just say it's a T-shirt, and you're going to apply this logo to it. Then that has to cross state lines.
The product
Your
itself.
product has to be in interstate commerce, yes. right, so just to summarize here, you know, you want a fanciful arbitrary mark, you want it distinguished from other marks, you gotta apply it, use it in commerce, get your registration application filed as soon as possible after your use in commerce. Use the superscript TM. Don't use circle R before you get your registration. That's trademark registration abuse. You can get your registration canceled if you do that. This is one of those, you create something, then you file something. And here's kind of I'm gonna send this to y'all so you'll have it. But there's the link for trademark application process filing online. You can do it online now. Any questions on trademarks before I move on to patents? Yes.
Does it apply also for interstate if it's a service as well instead of just a product?
That's right, yeah, service as well. I use goods most commonly, but it's a service mark, not a trademark when it's applied to a service. So for patents, we're talking about inventions now, not clever words, phrases, or slogans, logos. Patents are inventions. And I don't have quite as many slides on patents as I do on trademarks, and even fewer on copyright, so I'm just kind of breeze through this. In order to qualify for patent protection, we have to have a new, useful, non-obvious invention. It has to be proper subject matter. By new, we use what's called the single document rule, the single source rule. It cannot have been disclosed in a single publication. Whatever it is your invention is, if we look at this book, it's not in that book. This book, it's not in that book. Pretty easy bar to get over. Because most of the time, what are you doing? You're taking a collection of things from all different sources and you're putting it together. So, you know, occasionally we might find something in a single source, but that's the easiest bar to get over. Yes?
If you're doing research on campus and they require that you do some sort of documentation along those lines, would that count? Like as being part of documenting?
I'm not sure I follow.
Yeah.
If you're having to document, so if you're having a research study over a particular item like that you're wanting to develop, then, and you go ahead and publish that document, would that be, not be able to be patented? is what I'm saying.
That could be a bar to patent. Sure, yeah. If you publish what you're going to patent, absolutely, yeah. That's a big problem, and we'll talk about the 1-year rule here in a second. We have to be useful. You can't have a box of rocks or other sorts of nonsense. There has to be some utility to it.
You can trademark that, but you can't patent.
That's right. And non-obvious. You can't, obvious means to combine inventions from 2 or more sources. Sorry, it can't be obvious to combine 2 inventions from 2 or more sources or publications. This is our multiple source rule. So what that means is, okay, here's our 2, actually let's use the top one here, okay? We're wanting to patent the coffee cup. Did I have a next slide on this? No. We're wanting to patent the coffee cup with the handle, okay? We've got a single source with just a ceramic coffee mug, no handle. And we have, let's say another publication where we found handles. Would it have been obvious to somebody of ordinary skill in the art, is the term they use, to combine those 2 sources, coffee cup without a handle with handles, to make a coffee cup with a handle? That's the obvious analysis. We have to get over that. It can't be, it has to be non-obvious, or said another way, it can't be obvious. Yes, sir?
So what if it's applying a invention to a new application? For example, like the coffee cup and you have those cups that change color when you pour cold or hot liquid into them. Is that like patentable, or, I mean, because they
Don't know. Sure could be.
They didn't invent this.
How's that
this
useful?
person didn't invent this color changing thing.
Yeah, how's that useful?
Yeah, I don't know.
If we come up with some utility for it, like, this is dangerously hot, don't drink it, color change, maybe. But gimmicks and color changes and all, those sort of gadgetry type things, Patent Office is not enamored with. Look, watch this change color, you know, those sort of things generally fall into non-useful. We don't even get to a non-obvious analysis.
So what, assuming something like that is useful, some scientists discovered this color change or whatever else change, and they apply it to this product over here, and then start manufacturing that. Is that patentable? Like, assuming it's useful.
Well, okay, so the key phrase I kind of glossed over, would it be obvious to one of ordinary skill in the art? Okay? This fictitious person, somebody who has ordinary skill in the art, we're in the coffee cup business, all right? We're trying to patent this new coffee cup. And we say, would it be obvious to combine color changing technology with a coffee cup? I can't answer that question for you right now, just because, you know, that question, if you ask 10 different lawyers, you might get 10 different answers. If you ask 10 different patent examiners, you might get 10 different answers. It would also depend on sort of the factual predicate that you were able to lay before the examiner to try and justify why it's not obvious.
But what you want to try to patent there is the color changing process. Has nothing to do with coffee cups. Right? That's just one application of your patent, right? So, you know, the technology that you created to allow things to change color, the chemistry, the whatever, you might patent that process, but it has nothing to do with patenting a coffee cup, right?
If the color changing, exactly, if the color changing was something that was, you know, state of the art, hadn't been done before, we're breaking new ground, that would be in and of itself patentable. If we're down the road now where it's gimmicky and, you know, you can go get a 39-cent fish tank thermometer that changes color depending on the temperature of the water, you know, that this, you know, at some point, technology that's state of the art can become a gimmick later on. So it all depends on the context. I can't give you concrete answers right now of these fact patterns coming into your head, whether or not they'd be obvious or not. I don't know.
But if that technology was commonplace, it had already been patented, and way down the road, some guy thought of a new application for that material, non-patentable?
Again, it just
Maybe,
depends.
maybe not, right?
There's no bright line answers on this stuff.
Your attorney would have a hard time proving non-obvious there.
Yeah.
Oh, well, this technology was already here. They just decided to do water coolers instead of coffee cups. The patent office is probably, again, no set answers, but probably going to go, that's pretty obvious, right? You know.
Well, and I think we also need to, you know, kind of think about too, you know, put ourselves into the context of where we're at as students entering EagleWorks or students that are, you know, working on potential intellectual property in a makerspace, whereas not necessarily worrying about, you know, what would happen here, what would happen there. I think this is probably, I don't want to steal your thunder because I think this is where you're going, but is thinking about where do we as a student, where do we actually fit into this, and is this something, what do I really actually need to worry about legitimately? You know, I think that's something, does that make sense?
Right.
Yeah.
Right. Okay, so,
and you may be I may be a couple slides ahead of you, so go ahead. I don't want to derail you
I'm
there.
just kind of throwing out basic principles.
Yeah.
I hadn't answered that question. That's a great question, though.
Yep.
And we'll get into kind of practical application.
That's kind of what I figured. So, and that was really kind of more like, you know, what I was trying to say. Let me rephrase. What I was trying to say is don't necessarily put all your time and effort into thinking about, oh, well, what could happen if this happened, or if that happened, or all these disparate, things happen. Think about really, get the concept down of what are we actually after, and what do we think that we want to protect first, and then take it from there. Does that make sense? Because think about, like, y'all got a month up until this, and I think one rhetorical question for the moment is asking yourself, do I need to patent this? We asked one question.
Exactly.
The one question was, hey, I have to publish this, so I have no choice. But, maybe I do have this big, grand, huge idea for EagleWorks. We've had it before. Do I really need to get this thing patented, or can I? And I think you're going to talk about the 1 year and the provisionals and all that.
Yes.
So I'll leave it there. But
And keep in mind with patents, so this is as running the entrepreneurship. I'm not an attorney, but I deal with all these things on an everyday basis. So I call him when so what we want you to understand is you need to know these basic rules, but if you get to the point you're sweating it, call me and Kent will sit down and talk with you, or we'll get you with Kevin, or we'll get you with somebody. Where people get stuck is worried about, well, if I tell somebody, they're going to steal my idea. Well, you're going nowhere anyway if you don't ever tell anybody, so they might as well steal it. Nothing happens either way for you. And the other thing is, understand that 97% of patents filed in the United States never make enough money to pay the patent filing fees.
what he said, he articulated it better than me.
So from an entrepreneurial standpoint, quit worrying so much about patents. Go figure out if somebody will give you their money.
Right, exactly, yeah.
Universities in the United States own millions of patents. You want to know how many schools make enough to pay the staff that work in their tech transfer office? In the United States, 16.
Wow.
16 universities make more money on licensing than they spend on the staff in their technology office.
And furthermore, you can explain things as long as you can only, well, I can't forget what Kay says, but she says, Kay is our legal counsel for the university. Mm-hmm. She says, you can only give away what you have, right? Yeah. And if you think about that critically, I think that's a very important part, but you can expand that out of, you can only give away what you actually divulge. You may have this next big greatest idea for EagleWorks that very well may need a patent. We've had patents, 3 patents come out of EagleWorks. It's important. However, if you think about, okay, you're going into EagleWorks, obviously you're going to have to talk about your idea in public at the trade show. You're going to have to talk about it on the stage. Sure. However, you don't have to give away the trade secret or the secret sauce or whatever. You can talk in certain terms about how this is going to work without ever saying, we figured out that it's going to use this algorithm, and here's the algorithm.
Yeah, don't give us the chemical. Don't give people the chemical formula.
We don't
say I got a chemical that'll remove chewing gum.
Right.
But don't give them the chemical formula. Right?
We don't want that anyways. We don't. Remember you'll learn this again in pitch practice is we don't want to know a technical rundown. Looking at y'all engineers, technical is great, but that's not for your 7 minutes. It's we've got this. It's going to work. Moving on, right? So you're, like Jeff said last week, is you're not.
If you have a good product, you will know it. You know why? You'll be able to sell it. And one of the things that is key in crafting this non-obviousness argument in a patent response that your lawyer will prepare is unexpected commercial success. So you've got something that may be on the line, that seems pretty obvious to connect those two. But yeah, nobody's done it yet. I did it, and I made a ton of money doing it. That's a pretty compelling argument. So let the invention speak for itself. Those arguments and those things, it is what it is. Don't try and fit your invention into this. These are just kind of general guidelines for you to kind of take and say, all right, well, patent, we probably not need to worry about that yet. Let's go for branding. That's kind of the point of this, is just kind of give you some rules of the road, not make you stress out about, oh God, I got to fit in this box. Don't force fit your invention. Your invention is what it is. We'll figure out what rights it can get, how to protect it best, that sort of thing later on. Subject matter. You know, we can't patent gold, natural phenomenon, products of nature, abstract ideas. You're patenting inventions. Okay?
Can I patent a mathematical equation?
That business methods basically is what you're talking about. Yes and no. They've had business method patents kind of come on strong, and then they fell out of favor, so they're not quite as, they're a little bit more of a stepchild now of the patent office. They really scrutinize those things. Because of that, it's just math.
Right.
And they hate taking math out of the public discourse.
Yeah,
That's
right.
what you're doing, right? That's why we have such a high bar, these weird words. We don't want generic words becoming trademark, because then we've got somebody who can say, you can't use that word in common discourse. You can't use gold or math in common public discourse anymore. We need to have a high bar to prevent that, so that as a society, we're not just running around clobbering people over the head with, you know, you can't use this common word, you can't use this common invention, you can't use this, you can't use gold, you can't use math. It's absurd. You
Well,
first.
let's say you have a ridiculously complex computer algorithm in a big hedge fund, right? You wouldn't necessarily want to patent that computer algorithm, because then after the 25 years, everyone's going to take it. And
Yes, sir. You put that in code and you lock it up and you don't let it out.
So that would be
That's right.
a trade secret.
Yep, that's the
You,
last
you
one.
probably don't want to, remember, the minute you file a patent, everybody can see your algorithm.
Yep.
Yep. And everything else.
So whether you catch them using it or not is one thing. But when
Yeah.
you file for a patent, you go, here's my algorithm.
Yeah.
yeah, because what's that company, Renaissance?
I was gonna ask, at what point does a patent, like, not become a patent? Is that
Okay.
a patent?
If you file, the day you file, you get 20 years from then if your patent application becomes a patent. Kind of a weird way to look at it. They used to go 17 years of enforcement from the date of issue. Now they look at the date you apply and go 20 years from that. So
Because it takes about 3 years to get one
it takes
approved.
about 3 years. Yes, sir.
Oh, they're talking about create a patent, everybody sees the technology. Does anybody here know what a Delta robot is? All right, that thing on the table right there, that's a Delta robot. The idea that you can take 3 arms and position the effector, and it's a really, 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 really fast machine, and they use them for sorting. Technology's been around since like the early 80s. They got a patent, they wanted more than the license was worth, nobody was willing to spend it, or nobody was willing to pay it, so, and like 10 years ago, patent expired, and then every automation company in the world snatched it up.
That's right.
And it's replacing workers at an alarming rate, because it can perform sorting operations and stacking ultra fast.
That's the trade-off. For patents, you get this monopoly, it's really an exclusive, in exchange for fully disclosing your invention. Okay, you've got to, in painstaking detail, describe in your application what this thing is, how to make it, how to use it, all of that. And you get, as an individual, an exclusive right to make, use, and sell that invention for 20 years from the date of the application.
That doesn't-
In exchange for that, the day that thing expires, it lapses into the public domain. Everybody can use it. It's everybody's technology. Nobody's limited. You don't have to pay a license fee. You can't get sued for it. Now, you can shorten the effective infringement period, your enforcement period for your patent, if you don't pay your maintenance fees. There's 3.5, 7.5, 10.5-year maintenance fees. If you don't pay those within a certain time window, your patent can lapse. And they do that because they don't want patents that are just out there for basically patent trolls to be opportunistic. If you're not using it, if you're not making money with it enough to even pay the nominal patent fee, it needs to just lapse into the public domain.
You know, I think it's important to say too, and again, you may be getting to this, is that just because you have a patent does not mean that you can't still get ripped off. It just means that you have the
Oh,
ability.
let me tell you, nobody rips off crappy ideas.
Right, yeah, that's correct. That is
If
absolutely
you've got a
true.
good idea, you better believe, people only want the good ideas.
Yep,
And if you've gone to a lawyer, if you've invested the money in a patent attorney and getting a patent, it's probably a little bit ahead of the inventions that everybody else has. It's a little bit better. And so bank on it, you know. That's one of the things a good patent attorney tries to do is anticipate future developments, drafting that patent application as broadly as possible to capture some of this stuff that you're thinking like, all right, if I'm a competitor, I'm trying to rip this off, how am I going to get around this patent? You're constantly thinking that, so you're improving your client's patent application to ward off as much of that as possible. It may not be feasible to even do that. You may be in a very narrow field of technology where it's just that little incremental advance that's going to get you $1 million in 2 years, and then we're off to the next little incremental advance, and your patent's as good as gone anyway. Let me take a question from her first.
Okay, I had a question regarding like if someone decided to create a product and then not get a patent for it, is that eminent domain? And if somebody else comes along behind you and recreates that and tries to patent it, would they be denied?
Okay, so if somebody creates something and does not patent it, then if there's been a year go by, then that person who created that, as long as they've publicly used it or offered it for sale, they've done something to put the idea out there. If that's been more than a year, that's what's called your prior publication. That's our single source rule. So anything else that comes along is not going to be new, right? That's what our 1 year rule really does. It puts whatever that invention is in the single source rule. Yes, sir. You had a question.
On when a patent becomes public domain, is that true of provisional patents as well?
No. Well, for a provisional patent, it lapses after a year. And you have to have filed a regular patent application in order to convert it to a regular utility application. Provisional applications are very much a document that can serve as a single source rule and be a bar if you've not converted within that amount of time. If you don't convert, you can't then go back and say, so they can be a bar too. All right, a patent's protection is in its claims. This is a topic I usually don't cover very much. I just decided to do it. Has anybody ever looked at a deed to a piece of property? Yeah. A deed to a piece of property will say you start at this corner, you go this survey marker, a couple 100 feet to this corner. Well, that's what a patent claim does. It outlines the metes and bounds of your invention in words, very, very similar to what a property deed does. And claims are the mechanism that establish what the patent invention is and is not. Okay, a lot of times you will see a product, and the product looks similar to another product. Well, that's not necessarily an infringement. You have to look at what the patent claims say, not what the product looks like. An example, I'm going to draw on my coffee mug. A claim might read like this. This is really strange wording, but this is patentese. A beverage container comprising a cylindrical receptacle for holding liquid, having an open top end and a closed bottom end, and a handle attached to the cylindrical receptacle. That's what a claim in the patent world might read like. Well, yeah, let's go. So, in order to infringe, we have to have a product that has every element of our claim. All right, and I'll put the claim up here over to the side. A beverage container comprising one, a cylindrical receptacle, an open end and a closed bottom, open top end and a closed bottom end, and a handle attached to the cylindrical receptacle. Now, does this coffee mug have all three of those elements? Or all of those elements? No. No. So it doesn't infringe. So let's go back to,
So are you saying when you want to rip someone off, you have to read the line items and then add or subtract one thing?
bingo, yeah, exactly.
Exactly.
It's wordsmithing.
Yeah,
That's
it
what it
works.
is. That's what patent lawyers do when they get a
So-
client come in and says, here's this invention, how do I get around it?
So
With a big
essentially,
cheesy grin on their face.
so essentially, you're gonna have to shell out a ridiculous amount of money for a really good patent attorney or series of patent attorneys to make that a bulletproof wall of IP, you know, depending on the product. I mean, if it's
Yeah.
large commercial ideas, then I'm sure, you know, that's probably what you put funding towards is just that IP protection. But it sounds like it's pretty easy to rip something off.
Well, let's go, does anybody remember our basic elements of our coffee cup claim? A cylindrical container, an open top end, closed bottom end, and a handle. So I asked the question, does that on the top infringe? Now let's ask the question for our folks who have a sharp eye, does that infringe? This is the question that I get. How do I get around that? Does that infringe our claim? The coffee cup on the bottom? And if so, why? If not, why?
Does the lip of it, like where it comes out, mean that it's not
Concave shape.
cylindrical?
Bingo. So that would be the answer to our question, hey, I've got this claim, how do I get around it potentially? That would be one of the scenarios. Well, don't make it cylindrical. Make it anything but cylindrical. Make it, you know, flared at the top or conical or, now, this is getting into the weeds a little bit too, but there's this notion called doctrine of equivalence that patent lawyers in the Supreme Court have come up with to say, you know, you can't make stupid little aesthetic changes that don't mean anything and get around a patent. What you did is basically the equivalent of what's in that claim. Seems fair, right? So generally, under the doctrine of equivalence, which I didn't share with y'all, but under our strict claim analysis, that's not a cylindrical beverage container, is it? No, it's flared at the top. But under doctrine of equivalence, unless we can show some sort of significance to that flare, it's just kind of an aesthetic. Nah. It was an add-on just for somebody to try and cheat a claim. So that's our, that's just real basically and there'll be a ton of those little issues floating around about how we get, you know, this particular part of get around this particular part of the claim or that claim. This was very basic and fundamental, but that's kind of it. You know, hey, I want to make those. How do I get around this patent? Which is a legitimate question, right? In order to respect people's intellectual property rights, we don't want to take their intellectual property. We want to have our own. We don't want to infringe. And the world of patenting, you know, keep in mind, you get an exclusive monopoly on your invention. If your invention is that narrow, if that's what it is, then somebody ought to be able to make something that falls outside of whatever your invention is, right? Philosophically speaking. Okay, so I need to move on. Here we go. I don't know why these skipped around. I guess I got the slides out of order. I didn't rearrange them. Okay, so let's talk about, there's a recent Supreme Court decision just last month, I think, that talks about this 1-year rule, the on-sale bar, that sort of thing. Person shall be entitled to a patent. This is 35 U.S.C. Section 102B. You'll be entitled to a patent unless the claimed invention was patented, described in a printed publication. There's our single source rule. Patented also is a single source. In public use. All right, so when you've got a, let's just say we were showing things, concepts. This is a private setting. This would not be a public setting. Okay, so we wouldn't have to worry about public use right now. On sale, you notice I've got that highlighted. On sale.
Seems like that would answer your online question from earlier.
Yeah, I punted to this, right. On sale means what it says. Of course, if you sell the invention, the 1-year bar applies. You got to start the time ticking. A private offer for sale, even if it's rejected, is on sale. Yeah. So failed negotiations in a private context, not in a public context, even if you've got a confidentiality agreement,
The clock starts.
the clock starts. So any email, anything like that, that's potentially discoverable in litigation when they're trying to challenge a patent that you've got when you didn't tell them you had private negotiations that occurred 2 years before you applied for your patent. That's what happened in the Supreme Court case. I can't remember the name right now. 2 years prior to them filing, they entered into negotiations that failed. And they argued that, well, it's confidential. The claimed invention, we didn't have an invention, much less a claim. It wasn't quite ready, this sort of thing. They said, no, if you're ready to sell it, you're ready to patent it. Let's see. All right, so application basics. You have to have a complete written description, painstaking detail that would enable a person of ordinary skill in the art to recreate the invention with minimal experimentation. You usually have to have drawings. You have to have at least one claim. And you have to have a single invention. You're entitled to a patent for a invention. If you throw multiple inventions in there, they won't kick it out, but they'll make you pick one for prosecution here, and you can piggyback later on with future applications in the future. It just means more filing fees. And you can do the patent application process online. There's the website. Mark your product with patent pending. Do some checking. Make sure you've got this product. And you also want to make sure that you are not infringing somebody else, right? So do some checking. That's a little bit different inquiry. You can't go hire a lawyer really to say, hey, does this infringe anything? Well, no. I've got to have to look at thousands I don't know. Usually what you've got is a very discrete analysis. Hey, this looks like it might be a problem for me. Somebody's already patented this. Is my, and here's the patent for it. Here's the claims. Does my invention infringe on this patent or the claims of this patent? You get a little bit more discrete analysis. And you might, if you find something like that, you might want to do a workaround. Go to a patent attorney and say, hey, how do I get around this? Or get a non-infringement opinion. We'll spend just a tiny amount of time on copyrights. Copyrights is the expression of an original idea fixed in a tangible medium. You can't copyright ideas, you can only copyright the expression of those ideas. All right. Boy wizard defeats evil older wizard. Been there, done that. That's not copyrightable. The way J.K. Rowling expressed that particular idea is very much copyrighted. Here's the different categories we can get copyright protection for. Any work you use, you just put the copyright symbol. You don't have to register. Copyright registration is really simple. You print the forms from the Library of Congress, you check the box, fill in, sign your name, provide a couple of samples, and give them the filing fee. They'll stamp it. They don't do any analysis, not like the Patent Office or the Trademark Office. They just file it and they send it back. Copyrights. Yes, sir.
You know how much the fee is?
I think it's $20, something like that. Huh?
It's not bad.
Yeah. The problem is, like photographers, you take, thousands of pictures every outing. You don't want to send in a photograph at $20 every time you take a picture. You can do collective works, you can send in your whole thing with little photographs, I guess, collective works if you wanted to, but use the copyright symbol. Registration, they encourage early registration within 3 years of publication so that you get access to treble damages, attorney's fees, things like that if you actually have to file a suit. And finally, trade secrets. A trade secret is any of those things that gives you an economic advantage over your competitors who don't have it. That's number one. Formula, process, system, information, data, whatever it might be that gives you an edge, and you take reasonable measures to keep it secret. Doesn't have to be absolute measures, just reasonable measures. Reasonable under the circumstances. If you're Coca-Cola, reasonable under the circumstances is different than if you're a local tea aggregator. So we've got a federal statute. We've got all 50 states has some version of this. The USTA is uniform. I got it backwards. It's Uniform Trade Secrets Act. It's UTSA, not USTA. So we're kind of in opposite mode here. We're not disclosing. We have this proprietary algorithm that trades futures or whatever, and it's worth a mint, and people are snapping it up, and I'm not telling a soul how I did it. Whatever the secret sauce is that people are going crazy for, it's going to stay a secret. And we got to take reasonable measures to keep it secret. We're not going to file anything in the public domain. We're not going to send anything to the Patent Office. We're just going to keep it a secret and never tell anybody.
Real quick question on that.
Yes, sir.
What if you try to keep a trade secret, somebody figures out a way to do what you're doing or something similar and then files a patent?
On trade secrets, if they develop their own, if they figure it out, they figure it out. You don't have, if they didn't derive it from you, if they didn't steal it, if they didn't get it from third parties who they knew shouldn't have it, you can do that. You can sort of reverse engineer, if you will, various things. And that's one of the risks that you run, is that other people can figure out what the sauce is through experimentation or through whatever. Now probably would be a good time to talk about NDAs. This is where if you've got employees, if you've got a trade secret, a secret sauce, whatever, this is a legitimate agreement to have with your employees, no matter the level. You know, we talk about non-compete agreements. You know, there's only certain categories of employees who would qualify to be limited in their competition or limited by in their employment later. You know, you can't just limit everybody from working for a competitor of yours. It's only people with certain lines of work. Not so with an NDA. Anybody who has knowledge or access to the pieces or components of your secret sauce, they can be locked down while they're employed and after they're employed forever and ever, as long as that thing's a secret. They can be under an obligation to never disclose those secrets to anybody.
Let me interject something important here too. So actually two things. So Tennessee Tech, as myself, Andrea, and Jeff as a partner, we are all covered by a general university non-disclosure. Anything that you tell us about your EagleWorks project, I cannot go and tell another team. So I'm already bound by that. So is Andrea and Jeff. Jeff wouldn't do that to begin with, but just know that you know, through our partnership, that protects you. So you can come and ask us questions, talk about your intellectual property. We're here to help with that. And then secondary to that, it may or may not be a good idea, depending on what you think, to do an NDA with your own team members. That's left up to you all. We do not enforce that. But I would also say that, in your presentation, you're not giving up trade secrets or anything technical of that nature.
Well, I was gonna say, so I meet with about 500 entrepreneurs a year.
Yeah.
Don't tell me any of your secrets. I meet with so many people, I don't remember 6 months from now who told me this or this or this, right? So again, don't even tell us when you're working with us. Now, we may have a mentor at some point if he's a chemical expert.
Right.
You might want him to know your secret sauce. Well, then we'll do all the non-disclosures and all that stuff. But we don't even want to know. Kent talks to us, our board, and our mentors all the time. Why do you even need to know that? We're helping you decide whether it's a good business or idea. We'll help you hire a Kent, you know, and all those kind of things, but we don't even want to know, honestly.
Yeah.
And a couple things while he's getting ready, it touches on some things that why we do this with the EagleWorks students. So, you know, do you understand what a provisional patent is? So a provisional patent is a marker. It's fairly cheap to do. Even if you hire Kent, it's probably less than $5,000.
Oh, yeah. far
Way
than
less,
that.
right? And that gives you a year to do whatever you want, and you can still file a patent on it, right?
I need some technical help here. I've got
And
this on my
so
screen,
we
but
normally
this is
suggest you file a provisional patent, but don't worry about the full patent application yet. Go figure out if anybody wants it, because you can spend $50,000, $100,000 on a full patent, and it takes 3 years, right? And so, you know, you can get them for 5, but typically they're averaging about 20 right now, even with the ideas we run into. So, you know, you don't need to do that day one, go file a patent. The university doesn't. They file a provisional and then see what happens a year later. But when he's talking about these kind of secrets, and so, you know, Kentucky Fried Chicken and their secret recipe and Coke recipe and all those kind of things, so keep those secret. And then one of the things he's not going to talk a whole lot about, but you as your team, there's 3 of you in an EagleWorks competition, have this talk. Get out a piece of paper and say, we're going to be full partners. And we all agree not to give away any of our secrets. So the only problems we've run into in EagleWorks is a year down the road,
Right.
something actually starts to happen.
Yep.
And none of you 3 ever, one's graduated and taken a job. And so, you know, just have that talk is what Kent wants students to do. We're not telling you to go sue each other, but I mean, literally write down the 3 names. Here's who each is. We're agreeing that as of this second, you can always change it later if they sign and agree to it. But I mean, that's some of the things we've run into is that you didn't talk about those things. And we don't settle that fight for you. And that's another thing talking about patents. So a lot of people think a patent that the government tells Kent to stop. No. You go hire lawyers that average about $800 an hour to go sue them to make them stop. So a patent, you can have the greatest patent in the world, but if you don't have the money to defend it,
That's right.
it's not worth the paper it's written on.
Yep.
You know, they can copy it till the cows come home if you can't hire enough lawyers to stop them. And so nothing is, what we want y'all to walk away is none of this is clear cut. There used to be a great rumor, and when Kent and I started doing this, the faculty here was spreading this urban rumor that if you had it was called a poor man's patent, right? And so you write down your idea and you mail it to yourself. Oh, that can be defended in court. No, never ever has it been that way. That was a total urban myth, right? Because you were proven you had the idea first. The patent office does not care that you mailed it to yourself. Who started that years ago? Who knows? We have no idea. Never ever has there been a court case that you mailed it to yourself and you won a patent case. Never. There's not at any court in the country. And so, what we want you guys to do is come to us and ask questions. If you get concerned about this and things, come to us. That's what we're here for. But what we don't want is 3 students suing each other a year down the road because you didn't talk about those things. And most of you are not ever going to go forward that far after graduation anyway. But just simply have the same talk that all of us in the innovation world have with each other all the time. Hey, if we do something like this, I think I want to own 20% of it. Okay, somebody get a sheet of paper, and we'll at least make some notes, right? And so we're not saying this has to be complicated, but we want you to be aware of all these things. And what we're here for is we want you to know enough to say, I don't know, and call us. That's what we want you to know, because we'll get help for you. And then he's going to talk about this is a great urban myth, by the way, on college campuses of if I work on it in my dorm, the school can take my idea. Right?
Yeah.
We hear it all the time.
So this is Tennessee Tech's intellectual property costs. You notice it was just revised in 2019. Okay. And it's actually pretty good, I think, in terms of providing some clarity. Let me skip to.
Now, if you're a professor, that's a whole lot different set of rules, all right? But as a student, that's a whole different ball of
And
wax.
if you are working on grant-funded things, you gotta.
That could be a ball of wax,
That could be a ball of wax. Does not apply to I-Corps or the mini grants or anything like that.
Okay, so this is the scope. The policy applies to anybody employed, full-time, part-time, temp, to students enrolled at Tennessee Tech, other persons using Tennessee Tech's facilities and resources. So it's fairly broad, but let's go down here. I'm going to skip significant use for now. IP ownership. IP developed by intellectual property developed by persons to whom this policy applies shall be the sole and exclusive property of Tech if it's developed within the scope of employment. That's common. You work for somebody, whatever you develop during your work time belongs to your employer. Developed in the course of a project sponsored by Tennessee Tech. Is this a project sponsored by Tennessee Tech?
So, no.
Okay.
Not, because that would be a research project, is really what they're in. So, we have, I think in writing, do we not, from President Oldham, that anything that goes through the iMakerspace or through EagleWorks, they make no claims to unless you violate the policy elsewhere, that you went out and used huge resources.
Well, that's the next one.
And so this
Developed-
project is exempt.
This is, they're ors, not ands. Developed with significant use of resources. Developed other ways, but, so let's go up to significant use of resources. Utilization of Tennessee Tech
So they
funds.
did update the number.
They did. Personnel, facilities, equipment, materials, or other resources resulting in a direct, indirect, or depreciative cost to Tennessee Tech of more than $3,400. So $3,400 and a penny. And excludes Tennessee Tech office space, Tennessee Tech libraries and computers.
That's why the
So in other words,
iMaker
just-
space is in the library. This is a protected zone.
Yeah. Now, you may think $3,400 is a lot of money and it would take a lot to get there, but look at the categories. Direct cost, indirect cost. What is that?
The lights.
That is a number that an accounting, some accountant using witchcraft will come up with as a huge number. Depreciative cost, another witchcraft accounting term. So it won't take long for use of resources for some clever accountant, or really even a not clever accountant, using all three of these categories to come up with $3,400 and a penny. So be careful using anything other than, library, general surfing, things like that that are off limits for them counting. Just be careful about using other resources.
You go to a chemistry lab and use a bunch of chemicals in there and you get the TA to help you. That would be a.
That's getting
example of-
dangerous.
Yeah.
So come up here, everything here is for you all to use.
Using the internet, because it also says that it's generally available to all students.
Right.
Well, use of the internet, no, they can't say you used our internet to do your Google research, we get to claim it. No, they can't do that.
This policy's linked on the webpage if you ever really want to read it in depth.
Yeah.
Can't sleep at all, read this.
And
Yeah.
that's all I'm going to cover on
Okay.
that. Just that I don't think we're even, So definitely don't, any work done in class, subject to a professor's oversight, in the labs with equipment, things like that. Be guarded because that number can stack up quickly. Now, it's 6:45. I've probably gone way longer. That's okay. Y'all had a bunch of questions, and I like questions. I wish I could have answered all of them, but you came up with some really good questions that I hadn't been asked before. But I'm definitely going to go, particularly some of the online stuff. I'm going to look at that. I will sit down and shut up. I'm going to send this to Andrea and you, this meaning the PowerPoint, so you can click all these links. You'll have all the access to all this.
We'll get it up on the website in the
And
next few days.
then I'll, there's some other slides in there that deals with business entities and organizations. I ran long, so I'm not going to cover those. I will take any last minute questions. And how long are y'all going to go after this?
Well, I'll tell you what, let's do a shirt drawing and then you all, as long as you're here,
Okay.
is fine with us. But,
What I'll do, I'll just kind of stay and answer informal questions so the people that want to leave can, and the people that want to hang around and ask me questions won't hold everybody else up.
Yeah.
How about that?
very good.
And if you run across questions as we're going toward Eagle Works, get them to Michael or Andrea or
Yep.
me, and we'll have Kent take a look. If he doesn't have time, we'll get the university attorney to give it.
Yeah.
Actually, she's way slower than Kent, but we won't go down that path. But again, when you have questions, ask us. And we'll tell you, man, that's a really good question. We probably do need to actually go talk to an attorney, right?
There's always one every year so don't
Yeah.
don't hesitate to ask, because you very well may help us write new policy.
My thinking is just, people don't, as a whole, like talking in front of other people, and so for every one person who's willing to ask the question, there might be 10 others who just don't want to speak up and ask that. So generally, if there's one person willing to say it, there's interest out there from a lot of people. We just don't know it. So it's important to get questions like that answered. That is. Thank you.
Did everybody get a thing?
Time for the draw.
Ticket? Yes.
Is that a patentable term thing?
Yes, it is.
Yeah, okay.
Because I said so. They were separated by size. That purple one goes on top of the gray one.
Okay. Got it.
Oh, and I was monkeying with y'all's
Yes.
merchandise. I'm sorry.
Oh, you're fine.
I
It should
paused
go
somebody's
medium
shirt
large.
that they're gonna win in the raffle. Sorry about that.
All right.
All right, 147.
Oh, that's me.
Yeah, all right.
Come on
Come up and claim your shirt.
All right, 115.
Do you know what the
We got
current-
purple, we got crazy color.
Do you know what the current trademark
115.
fees are?
Must have.
I get people ask me that every day, and I can never remember what they
138.
I think it's 325.
I was gonna, I was saying 350 or
Yeah,
something.
I think that's per
134.
channel conflict.
We need the bear.
All right, very good. So,
If
grades,
people say
have your
that, say
choice. So,
134,
extra large,
then
large.
I will make them. 140.
Giving shirts away. He must have left.
All right.
We'll have one left over.
128.
Also,
How many are left?
we have two left after this one.
Okay.
All right.
All right. 142.
All right. Very good.
All right.
They're both the same, so there's that for you.
And 143.
All right. 143. Okay, well, I'm taking it home for myself then.
Do you know how many more I have?
This is the point I usually
116.
win the medium.
Yeah, right. Pretty decent
116.
sized medium though.
Okay. This is the last one. If I don't draw someone, then whatever.
You got it?
127.
Is that you? Hey, all right.
There we go.
Very good. So, Kent will be around
Yeah.
for your questions.
I
Do
mean,
you all,
it'll be in-
did you stop the camera, Andrew?
Oh, no.
So, before we break, before y'all